Thanks, Liz. So first, I just want to say that I have two toddlers, so you may be hearing noise in the background, and they are not having a good day. Not having a good day, and neither is the babysitter. So if you hear screaming in the background, it's not a horror movie, it's just my toddlers. My name is Dana, and I am a senior staff attorney at the Disability Law Center of Virginia, and have been there since 2000. Today, sort of my area of expertise, if you will, is guardianship and alternatives to guardianship and how to avoid guardianship. And that's what we're going to talk about today. So let's get right into it. So normally when I do this in person and I like to interact with the audience, I ask the audience, who is the expert on your healthcare? And the answer to that, of course, is you. You are the expert on your healthcare. And if you have a child, whether that child has a disability or not, who is the expert on that child and that child's healthcare? The parent. Now, what if, so if I'm the expert on my healthcare, then I'm the one that should be talking to my doctor. I'm the one that should be making decisions about my healthcare, and I'm the one that should be able to say yes or no to a medication or a treatment. What if something happens, I'm in a car accident or something happens and I am unable then to talk to my doctor and make those decisions? Then who would be the person that would step in and do that for me? Who would be the expert then? And most of the time people will say next of kin or, you know, variations on that. But truly, I'm still the expert. That doesn't change just because I'm unconscious and can't communicate for myself. So how does that work? It works by putting things in place ahead of time so that I'm still able to make my own medical decisions. I'm still able to communicate to my doctor. I'm able to put someone in place who's going to be my voice for me when I can't speak for myself. If I put all of those things in place ahead of time, then I'm still the expert and I'm still making decisions for myself. And so that's what we're going to talk about today. And not only for an individual with a disability that you may be supporting or maybe parenting, but this is relevant for everybody. We all need to think about this because we know things can happen in a heartbeat and we may be in a situation where we're not able to communicate for ourselves. So we're going to start off with some vocabulary to make sure that we're all on the same page and we're all using the same language. And the first word is very important to what we're talking about today, and that's capacity. Capacity is the best, easiest definition I've found for capacity is it's the ability to do three things. It's the ability to take in information, make a decision based on that information, and then give your choice, communicate your choice. Now, some important things to think about there, the ability to take in information. That in order to truly know whether the person has capacity, you have to give them information in the form that they take it. So if someone speaks Spanish and speaks no English and I give them the information in English and they don't understand it and they can't make a decision and they can't communicate their decision, that doesn't mean they don't have capacity. It means I have failed. I have not given them the information in the form that they can accept it and understand it. The same thing is true for people with disabilities. We all know that people, well, we all communicate in different ways, but a lot of times people with disabilities, especially those with cognitive and intellectual disabilities, may take in information differently. They may need it in simpler language. They may need more time to process. They may need someone they trust to give them that information. They may need somebody to listen to the information that comes from the doctor in those $10 words he wants to use and break it down so the individual understands it. So a lot of times I think people are found to lack capacity, not because they truly lack capacity, but the individual giving them information failed. So Number one, the ability to take in information in the form that they need it given to them. And then make a decision based on that information, and then communicate their decision. That third part, same thing as the first part. They may communicate differently. They may not be able to verbally give their decision. They may do it in gestures. They may use pictures. They may, I mean, a myriad of ways that people communicate. And if a medical professional is not willing to accept that form of communication back from the individual, they may say the individual lacks capacity when they truly don't. So why is capacity important? It's important on the front end, and it's important on the back end. It's important on the front end because when we're talking about alternatives to guardianship, it requires the person to have capacity. It requires the person to be able to take in information, make a decision, and communicate the decision about the alternative they're choosing. Okay, and we're going to talk more about that as we get into the presentation. It's important on the back end because if the individual lacks capacity, that's when someone is going to have to step in and make a decision for them, whether it be someone they chose ahead of time or whether it's going to be going to the court and getting a guardian appointed. We're going to talk more about that. Okay. So advanced directive. I see advanced directive as an umbrella term, okay? It is the general term for all the types of advanced planning we put in place. Under advanced directive are the bits and pieces that make it up. So the power of attorney, that's a document where I can choose someone to make decisions for me when I can't, all right? If I lack capacity because I'm in that car accident and I am unconscious, I may have named someone, I may have said, Liz, if I'm not able to make decisions for myself, I want Liz to make decisions for me. That would be a power of attorney. A living will is when I put in writing what sort of care or treatment I want or don't want. If I'm at the end of my life, I have an incurable illness or injury, or in Virginia, they also include what doctors call a persistent vegetative state. I hate that term, but that's the term that's used. So if I am in basically a permanent comatose state where I'm not going to wake up and I'm not aware of my surroundings. So if I'm either at the end of my life or I'm in a persistent vegetative state, what type of care or treatment do I want or don't want? And normally the choice is, do I want life support to keep me alive as long as possible, or do I want to just be kept comfortable until naturally I pass? That's a living will. A medical directive allows me to put in writing my wishes and preferences about all other types of healthcare. I can put in there what medications I'm willing to take or don't want to take, hospitals I want to be treated at or not, doctors I want or not, what calms me down if I'm upset, all kinds of things that deal with my healthcare. In Virginia, we have what's called an integrated advanced directive. And what that means is we don't have a separate advanced directive for psychiatric care. About half the states do. They've separated out the psychiatric piece of it. And so all your mental health directives and preferences are put in a separate document. When Virginia looked at this issue in 2009, they decided the head is actually attached to the body and decided to make it integrated. So you can put mental health treatment preferences in the advanced directive without having to have a separate document. So those are the terms that I want us all to be on the same page. We've talked about capacity. Now, the important thing about capacity, one of the important things is capacity in Virginia is presumed. So when someone signs a document, they are presumed to have capacity to sign that document. When someone goes to court, they are presumed to have capacity. That presumption can be what lawyers call rebutted. So basically what the law says is someone has capacity until they don't have capacity. That's pretty clear, right? So how does someone lose capacity? If capacity is presumed, how do they lose that presumption? There are two ways in Virginia for someone to lose capacity. One is a temporary capacity loss, and that's when two doctors determine that the individual does not understand the decision that needs to be made. How that normally works is, I met the doctor has told me about a new medical diagnosis that I have, and he's telling me about the treatment options, and then he's asking me questions, and by my responses or non-responses to the questions, he thinks I'm not understanding this and I'm not going to be able to make this decision myself. Well, in Virginia, that doesn't mean I've lost capacity. The next step is he has to bring in another doctor who is not my treating doctor and ask that doctor to talk to me about the decision and whether I understand it. Now, if that second doctor says, Dana's not understanding this, she's really not able to make this decision on her own, then at that point, I now have lost capacity to make the decision that needs to be made. The Virginia law says that the doctor can determine that I don't have capacity for one particular decision that needs to be made, or a series of decisions, or that I truly lack capacity to make all medical decisions at that point. The series of decisions would be, let's say I have a diagnosis of a brain tumor, and there are going to be several decisions that need to be made along the way based on that diagnosis. Then the doctor can say, I have lost capacity to make all of those decisions about that diagnosis. So some other important things to think about capacity is that capacity is not this on-off switch, you either have it or you don't. Unfortunately, a lot of medical professionals, I think, see it that way, and mental health professionals as well. Capacity is fluid. It changes from time and circumstance. It changes for some folks, even the time of day. If any of you professionals on the call are aware of sundowning in older folks, I mean, they have capacity throughout the day, and then when it gets later in the day, that capacity wanes a little bit. It also changes based on the environment sometimes. So if I am meeting with someone for the very first time, they don't know me, and they have a disability, like a cognitive or intellectual disability, they may not be as forthcoming with me. They may not want to talk to me. I haven't developed that rapport. They may not trust me. So I may not, it may seem like they don't have capacity at that point because they're not answering my questions or they're not answering them appropriately. But the fact is, it's the circumstance. It's the fact that I'm a new person. And how much more would that be true if they're sitting in the doctor's office with the guy wearing a white coat and, all this medical equipment everywhere? They may shut down. So that doesn't mean the person lacks capacity. It just means in that circumstance and at that time, they're not able to take in information, make a decision, and communicate. There are also different levels of capacity. So when I read a medical record or talk to someone and they say, oh, Liz lacks capacity. Sorry guys, I have a parrot, so you might hear my parrot every once in a while chime in. He thinks he knows about this topic because he's heard this conversation so many times. If I read something and says Liz lacks capacity, to me that's an incomplete sentence, and that's sort of a pet peeve of mine. Lacks capacity for what? I've met very few people who truly I can say this person lacks capacity, period. So I think capacity is on a spectrum, and I say it's on a spectrum from P's to brain tumor. That's my spectrum. So I have two toddlers. They can very clearly tell me whether they like peas or not. They have the capacity to tell me whether they like peas. They are able to determine that on their own, take in information, how they take it in, make a decision, and then communicate the decision how they communicate it. Whether they throw them on the floor or give them to the dog or whatever, they are able to communicate to me that they don't like peas. They have capacity. So that's, if I were in front of you, I'd be pointing to the floor. That's the level of capacity for peas. All right. And then let's say I'm in the doctor's office and I've just been given the diagnosis of a brain tumor. There are several options for treatment. Okay, capacity level for that is very high, okay? Because I'm going to have to take in a lot of information and make a decision based on options, pros and cons, benefits, side effects, whatnot. So the capacity for that is very high. So every decision I make, and how many decisions do we make in a day? I mean, we've probably already made many decisions today already. And so every decision we make is somewhere on that spectrum between P's and brain tumor. So do you understand why when I say Liz lacks capacity, that's an incomplete sentence? Does she truly lack capacity all the way down to P's? Or is it somewhere in between? So we're going to talk about capacity as far as some of these alternatives we're going to be talking about, such as doing an advanced directive, and how the capacity level is different for, let's say, choosing someone to make a medical decision for me, as opposed to actually making that decision. So making the decision about the brain tumor treatments is this level of capacity, but choosing who I trust to make that decision for me if I can't is much more closer to P's. Okay? All right. Normally I'd be looking for people nodding heads or whatever, so I really missed that feedback. So we've talked about that. So we've talked about that I am the expert on my health care. And if a decision needs to be made about my health care, I should be the one making it, if at all possible. And if I can't, then hopefully I've put something in place ahead of time, one of those or all of those parts of an advanced directive ahead of time, so that I'm still making my own decisions, or I have someone who is my voice, or both, to make those decisions for me. Now, what if I haven't done that? What if I'm in this car accident, I'm unconscious, and I'm not able to communicate for myself? I have not done an advanced directive. And I will say that the last study that I read, 85% of Americans have not done an advanced directive. Think about that. 15 people out of 100 have actually done one. So most of the time when someone's in that situation, they have not done an advanced directive. So what happens then? Virginia has what's called the Healthcare Decisions Act. And that says if I'm in that situation, I can't make decisions for myself, and I have not thought ahead and done an advanced directive, then family members can step in and make decisions for me. They have given a specific hierarchy of who those family members are. And the doctors have to follow the order that's in the law. And the order is, number one, spouse. So if I am married, my husband or my wife is going to be making medical decisions for me if I can't and I haven't done an advanced directive. Now, a couple of things to know in Virginia. We do not have common law marriage in Virginia. Virginia, the law does not recognize common law marriage. So if I have been living with my mate for 50 years, we have raised kids together, we own a house together, everybody thinks we're married, we argue like married people, we are not married under the eyes of the law if we have not done the steps that are necessary to have a legal marriage. If I am then in the hospital, that person will not be making medical decisions for me unless I've named them an advanced directive, and may not even be able to visit me in the hospital because they are not a family member, depending on the hospital's rules and policy. The law also says that that person, if I'm married to someone, that person is my spouse until I have filed papers in a court to begin to dissolve that marriage. So divorce doesn't have to be final, it just, I have to have submitted something to the court to end that marriage. So some folks, you know, they separate and they never take that next step. And 20 years later, they get into that car accident. And who legally can make decisions for them? That spouse. Okay? So if I'm not married legally in Virginia, the next level down, adult children, adult child or adult children. Now, if there's more than one, I ask folks who they think would make that decision, and probably about 95% of the responses are the oldest, but that is not the case. Virginia law says that if there is more than one in that level of decision making, then the doctor may go with the majority. So my piece of free legal advice for you today, so that you don't have a tie in this situation, is to have an odd number of children. Yeah, never mind, don't worry about that. Just put things in writing ahead of time so you don't even get to that point. Let's talk a little bit about children. These are your biological or adopted children. If the child is adopted, it has the same rights as a child as if you had given birth to that child. It would not include stepchildren if you have not adopted those stepchildren. It would not include foster children, and it would not include in-laws. So for the women in my audiences, it's usually really comforting to know that neither your daughter-in-law nor your mother-in-law will ever be making medical decisions for you unless you specifically name that person in your advance directive. So if I am not legally married and I don't have any adult children, then the next would be parents, if they are still alive. If they are not alive or available, then it goes to my siblings. And if I have more than one, the doctor may go with the majority. And if I get down to that and I don't have any living siblings, then it goes to family members, blood family members, such as aunts, uncles, cousins, niece, nephew. And again, it's blood relatives, so it would not include anybody who's like your aunt by marriage. It would be your blood relatives. So you can probably, if you think about how this could get really sticky. You have people that don't agree, and you have a bunch of people maybe trying to make a decision and trying to come to a consensus. This is where sometimes families can fall apart. Families can get into disagreements and hurt feelings and whatnot that maybe never mend. And so do your family a favor, protect yourself, but also your family, and do these things in writing ahead of time. Make these decisions for yourself so that your family is not put in that situation where they're having to make the decision. Now, one thing I want to talk about the Healthcare Decisions Act that's very important. Everything in the Act says the doctor may take the consent from a family member. The doctor may take the consent from a majority of members. The reason that's important is because in the law, the difference between may and shall is very important. So if I have an advance directive, the doctor shall follow it, okay? The doctor must follow my advance directive, what I've put in writing ahead of time. If I haven't done that, then the doctor may go with my family members or may go with the majority. And that's important because the advance directive obviously protects me more than relying on the Healthcare Decisions Act and that word may. If the doctor does not feel comfortable, say there are 5 adult children and 3 say, pull the plug, don't do life support for mama, and 2 are adamantly opposed to it. The doctor may decide to go to court and let a judge decide that. Why? Well, he may not feel comfortable going with the majority, and he may be afraid that he would be sued for that by the 2 that don't want her removed. So it just protects you and it protects your family to go ahead and put those things in writing ahead of time. Some other decision makers, the Authorized Representative, for anybody who has any dealings with a licensed or funded program of the Department of Behavioral Health and Developmental Services. You're probably familiar with the Authorized Representative, or AR. That is a person who is chosen by a program operated or funded or licensed by the Department of Behavioral Health and Developmental Services to make decisions for someone who's been declared to lack capacity using that 2-doctor method of lack capacity. The thing to know about Authorized Representative is that person makes decisions for that program only. So if the day program that's licensed by DBHDS appoints an AR for that program, that AR is making decisions for that program. The group home may have an AR assigned to make decisions in the group home. Now, a lot of times it's the same AR. If it's the day program, the group home, case management, every licensed program has the right to appoint an AR if someone lacks capacity. The really important thing is that the AR has no authority whatsoever when it comes to doctor's offices, hospitals, anything outside of the DBHDS licensed programs. So if an individual leaves a group home with their AR and goes to the emergency room, that authorized representative has no authority at all at that hospital. So that is very program specific. Now, if the individual who lives in that group home and goes to the day program has an advance directive and names someone in their power of attorney to make decisions for them, that person would be able to make decisions across programs and including doctors' offices, hospitals. And so that is a more inclusive and comprehensive way to choose a decision maker. Guardianship, we're going to talk a lot about, well, quite a bit about guardianship later in the presentation. But in order for someone to become a guardian, there has to be a court process. If we're talking about an adult, there has to be a court process and there has to be a court order that appoints someone as a guardian. And that's how that person becomes the decision maker for somebody else. And finally, if none of these things work and we can't reach an agreement, the judge is there. There is a court order. You can't have a court order for medical treatment. But I don't know about you, but I really don't want a judge making my medical decisions. Again, put these things in writing ahead of time. All right. So advanced directives, we've talked about the different parts of an advanced directive. A living will is only for end-of-life decisions, or in Virginia that includes persistent vegetative state. Power of attorney, healthcare, and remember in Virginia it's integrated, so it includes mental health care. You can also have a power of attorney for financial decisions, and you can have a power of attorney for educational decisions if a person has an IEP. Over the age of 18, the rights given to the parent under the IDEA then goes at 18 to the child, or then 18, that person is an adult. But you can have a power of attorney so that the parent is still able to have a voice in those educational decisions. That's called an educational power of attorney. So if I name Liz to make decisions for me when I can't, a lot of people will say, well, Liz is my power of attorney. And everybody knows what she means. Technically, Liz is my agent in my power of attorney. Power of attorney is the document itself, and the person I choose to make decisions for me is my agent. You can share that with your friends at your next dinner party, that little distinction. It'll make you so popular with your friends. You'll be such a nerd. But Liz would be my agent in my power of attorney. Obviously, the person I choose to be my agent, obviously, trust has to be there. I have to trust Liz. I have to trust her that she's going to do things based on what I want, not what she wants. I have to trust her to look at the pros and cons, talk to the doctors, look at the different options, and make the decision that I would make if I could. That trust is so important. It's also important that she be willing to do it. Whenever I talk to someone about advanced directive and talk to them about how they thought about who their agent would be, one of my first questions is always, have you talked to that person? Are they willing to do that? It's a major responsibility for someone to make decisions about your health care, up to and including end-of-life care. So life and death decisions, you need to make sure the person's willing to do it. Are they available? In our society now, we're always available, right? I mean, we always have our cell phone. I mean, we have email, fax, private message. I mean, we have all different kinds of ways of being available. But think about that if, you do have someone, you want to name your grandmother and she still only has a landline and doesn't have email. I mean, is she truly available when you need her? I'm going to skip co-agent and alternate just for a second and talk about the other two, and then I'll come back to that. So Liz and I may not have the same belief system or the same values. We may have totally different religious beliefs, totally different spiritual beliefs, totally different values of life and whatnot. But if I trust her to make decisions for me based on my beliefs and my values, then she could still be my agent. Because I've had people ask, well, you know, they're not the same religion as me, and I think their feelings are different. Can they still be my agent? Absolutely. You just need to make sure that they're going to be able to speak for you, be your voice, not their voice when the time comes. Conflict of interest, the person you choose to make decisions for you, let's say they're going to be like making life and death decisions for you, and they're also going to be inheriting everything that you own. Well, if you're like me and you work for a small private nonprofit agency and you know you're making boatloads of money because you're working for this small private nonprofit, you know, that may be, you know, I may not want to choose the person who's going to be inheriting everything to make those decisions for me, but that's just a personal thing to think about. Let's talk about alternate or co-agent. So let's say that Liz is my agent and a power of attorney, and we're out shopping and we're both in that car accident, and now we're both unconscious. So Liz is the person I chose to speak for me, and now she can't do it. So what happens then? Well, hopefully I have named an alternate. So I say I want Liz to make decisions for me if I can't. If Liz is not available or unwilling to make this decision, then I choose Nancy. And if Nancy's not available or willing, then I choose Christy. And so it can go on down the line. You can have as many alternates as you want. I recommend writing in a power of attorney that way with alternate agents. There is another way of doing it with co-agents. And that's to say, if I'm not able to make a decision, then I want Liz and Nancy to be my co-agents. Can anybody see a potential problem with naming co-agents? Hopefully you're thinking, what if they don't agree? And that is the problem with co-agents. So I have, sometimes when I work with folks who are just turning 18, they want to name mom and dad as co-agent. And if they, for some reason, don't agree, then it creates a problem and their advance directive may not be able to be used. So I recommend naming one person having the job at a time. I have written it so that the agent has to consult with the alternate agents before a decision is made, but there's still only one decision maker at a time. It makes it cleaner, neater, and more likely that you'll be able to use your advance directive when the time comes. So I can choose the powers that my agent has in a power of attorney. I can be very specific about it. They have this power, but they don't have that power. Or I can be very general, you know, about they can have all the powers that are granted to an agent in a power of attorney. Some of the limitations, do I want my agent to make end-of-life decisions, or do I want the doctor to have to follow what I put in writing? Do I want my agent to have control over who visits me if I'm in the hospital? Organ donation, admission to a psychiatric facility. How about treatment over protest? If I've been declared to lack capacity, so I'm not making decisions for myself, but at the same time, I'm protesting the decision that's being made. How do I want that handled? I can put all of that in my power of attorney document. And finally, do I want my agent to have the authority to sign me up for medical research if I'm not able to make that decision for myself? So those are some of the very specific things I can put in my power of attorney, or I can keep it more general. So medical directives, like I said, you can put pretty much any type of medical treatment, you can put in writing ahead of time. So I think of the medical directive like it is my voice when I'm not able to speak to my doctor. So I look at it as if I'm going to a new doctor. And you know, when you go to a new doctor, they want to know all kinds of information, and you're giving them information about what medications you take and side effects you're not willing to deal with and medications that haven't worked for you in the past. Your medical directive can provide all that information if you're not able to communicate at the time. So some choices that I can include if I so choose. It's really wide open. That's why other is at the end. Virginia doesn't put any limitations on what you can put in your medical directive. I can put what hospital I'd prefer to go to or not go to. The same with doctors, medication, any type of treatment. ECT I put here, but it could even be dialysis. It could be chemotherapy. So I can put in my medical directive choices about any type of medical care in writing ahead of time. So it speaks for me when the time comes. Once I've put all of this in writing, whether I've chosen an advanced directive or a medical directive or both, then I have to make it legal. And in Virginia, the way to make it legal is to sign in the presence of 2 witnesses. A notary is not necessary in Virginia for a healthcare power of attorney, but I do recommend it if you're able to get it notarized. It doesn't make it more legal, but it sort of has that optic. It makes it look more official when it's notarized. And you may be going to a state that requires a notary. The state should recognize the advanced directive without a notary, since we don't require it in Virginia, but it might make things move faster if it is notarized. So I recommend it, even though it's not required. What is required is 2 witnesses. So that means that if I am signing my advanced directive, there need to be 3 people in the room, me and my 2 witnesses. I cannot sign a document and 2 days later say, hey, would you sign this for me as a witness? The witnesses have to be in the room with me, okay? You don't have to have an attorney to do this. We have on our website, dlcv.org, and it's on the last slide, we have a supported decision-making resource page. On that page, we list, we have a do-it-yourself power of attorney with line-by-line instructions and a do-it-yourself advanced directive, a full integrated advanced directive with line-by-line instructions. I created it sort of like the tax form. Line 1, this is how you fill it in, and these are the things that you think about as you're filling it in. So check those out. On that supported decision-making resource page, we have videos to watch. We have information sheets about guardianship and alternatives. It's loaded with information, so please check that out. I just mentioned, I said whether you have a medical directive or a power of attorney or both. So if I put everything in writing, why do I need a power of attorney? Why would I need to put everything in writing and have someone speak for me when I can't? The reason for doing that, I mean, some people may choose one or the other, but the reason would be having that advocate, having somebody advocate for what I've put in writing, making sure the doctor follows it. And also the reason for doing that is I don't have a crystal ball. I can't think of everything that might happen. So even though I'm putting down in writing everything that I'm thinking about at the time, something else may come up, and I want to have somebody to speak for me when that comes up. But mostly it's to have that advocate, having somebody speak for you. Once I have decided what I want, done my documents, I've signed it in the presence of 2 witnesses, preferably with a notary, then I need to make sure that whoever needs it has it. So it is not going to do me any good whatsoever if I go to all of this work and I stick a copy in the family Bible and I put another copy in my safe deposit box. Because when does your family get access to your safe deposit box? After you're dead, okay? Sometimes if it goes through probate, it's quite a while after you're dead. So it's not going to do any good then for them to say, oh, doggone it, she did want life support. That's not going to do you any good whatsoever. So the only way this document works is if people have a copy of it. You're going to make sure that your agent has a copy. If you have more than one agent as alternates, you're going to make sure each one of them has a copy. so that if they need to show up to the hospital, they can show the hospital, look, I have the authority to speak for Dana. Make sure your doctors have a copy, all your specialists, all of your doctors have a copy of it. Your local hospital or hospitals. Here in Charlottesville, we only have 2 hospitals, so it's pretty easy. I can take it to UVA and I can take it to Martha Jefferson. I understand that if you register your advanced directive with, say, Centera, it covers all Centera. I'm not sure if that's the case, but if it is, that would cover a lot, and then other conglomerate corporations as well. We also have in Virginia a state registry, and it's free and it's easy to use. And what you do with that is you upload or fax your signed copy, and they put it on a state registry and send you a card that says how to access it. You keep that card with your driver's license or your ID, and if you are unable to speak, they will find that card with your driver's license, because that's usually what they're looking for. If you are unconscious, then they'll be able to access your advanced directive without you having to carry it around in your pocket or your purse. You also want to, even if they don't have copies, let other family members know, the family members that were not chosen to be your agent, let them know ahead of time. Don't let, you know, say my mom chooses me as her agent because I am her favorite child. So of course she'd choose me. But don't, you know, I wouldn't want it so that mom is, like, say, in a coma and my brother show up at the hospital and I wave a paper and say, mom chose me, I'm making all the decisions. This is a conversation you should have with your family, so that everybody knows what your decision is before that time comes. Other people you may want to give a copy to: case managers, day programs, group homes, spiritual counselors, pastors, anybody that is important to you and you want them to know, hey, when this thing happens, if it ever happens, and I'm not able to make decisions, I want you to know what my choices are. Now, when you're handing out all those copies, you get a copy and you get a copy and you get a copy, you want to make sure that you keep track of who got those copies. Because if you ever want to change your advanced directive, or you ever want to write a new one, you want to make sure that everybody that got a copy gets notified of those changes. Revoking an advanced directive is easy. You, if you write a new advanced directive or power of attorney or any parts of an advanced directive, the new one is the one that is valid. But remember, if someone has a copy of an old one and you haven't informed them that you have a new one or that you've revoked the old one, then they can still rely on that old one. So just make sure if you write a new one, you let everybody know. You can tear up copies. You can ask your family members and agents to tear up old copies. Doctor's office have this thing about tearing up official documents, but just ask them to mark it that it is no longer valid. So oral versus written revocation, I can, as long as I have capacity, I can still orally revoke my advanced directive if I do it in front of my doctor, straight to my doctor. So let's say I have put in my advanced directive, my medical directive part of that, that I do not want life support if my heart should stop. You know, I just want to go naturally. And I go into the hospital after the car accident and I know it's really bad. And I feel myself getting ready to go under. And I grab my doctor by the collar and say, I want to live, don't read my advanced directive. I have just orally revoked that, that decision in my medical directive. And at that point, they will do everything to keep me alive. So I can orally revoke it. I can revoke an advanced directive as long as I understand the nature and consequences of my actions. So basically, as long as I have the capacity to make the decision about revoking it, I can revoke it. Whenever you revoke or change your advanced directive, if you put it on the registry, you certainly want to let them know so that they have the most recent copy. If you're like 85 people out of 100 and you haven't done any of these things, then you go to what we talked about before. the Healthcare Decisions Act, all down that hierarchy of people to make decisions for you. An authorized representative, if it's a DBHDS licensed or funded program, the judge could make a decision for you under court-ordered treatment, or someone could go to court and petition for guardianship so that they can make the decision for you. We've talked about the Healthcare Decisions Act. So let's talk about guardianship. What is guardianship? So remember I said there are two ways in Virginia to lose capacity, and we talked about one. One of them is my doctor thinks I don't understand, brings in another doctor, that doctor thinks I don't understand, so I have lost capacity to make that decision or series of decisions. That's one way in Virginia to lose capacity. The other way is to have a court determine that I do not have capacity and appoint a guardian for me. So it has to be a court order that says that I have lost capacity and that a guardian is appointed for me. Sometimes parents of children with an intellectual disability or a very severe developmental disability assume that they will continue to make medical decisions for their adult child after the age of 18. Sometimes that does continue after the age of 18, but not because of the person's guardian, but because the doctor is following that Healthcare Decisions Act, and they are the parent, and therefore the doctor may accept the consent of the parent. You are not an individual's guardian over the age of 18 unless there's a court order stating that. So when someone talks to me and they say, I'm the guardian of this person, if I'm going to get very far into that case and provide any sort of services, I have to see that guardianship order. Number one, to make sure the person really is the guardian and it is not misunderstanding that term. But number two, the court order is going to lay out what authority the guardian has. Because we have in Virginia what's called a limited guardianship. And so the judge may give the guardian the right to make some decisions, but not all. So I'm going to need to see that guardianship order to see what types of decisions the guardian has the authority to make. And if you're a professional and you're working with folks, I highly encourage you to do the same thing. Look at that guardianship order. Make sure it says what the person says it says, and make sure they have the authority to make the decision that they are attempting to make for the individual. It is often confused. People will think they're the guardian because they have a power of attorney. And they are two very different things. The power of attorney or any parts of an advance directive do not have to have any sort of court procedure at all. You don't even have to have a lawyer involved, much less the court. Guardianship, you definitely will have a judge and probably at least one or two lawyers involved. In Virginia, we bifurcate the financial decisions from everything else. So a conservator in Virginia is appointed by the court if a person lacks capacity to make decisions about their money or their finances or their estate. And a guardian could be appointed if the person lacks capacity to make all other life decisions. So if someone has a conservator order and they have been appointed the conservator and they're trying to make medical decisions, a conservator does not have the right to do that. A conservator only handles issues of finances and the estate. So be careful with that. If someone brings you in an order and it says they've been appointed the conservator, they should not be making medical decisions. Often when someone goes to court to be appointed as guardian, they will do both at the same time. They'll get the guardianship and they'll get the conservatorship at the same time. So why, in the beginning of this conversation, this presentation, why didn't I just start with guardianship? Why did I spend all that time talking about things we can do to avoid guardianship? The reason is guardianship should be the last resort. It should be the last thing that we think about after we've gone through other options. Why is that? Because it takes away basic civil rights. In the legal world, guardianship is called a civil death, meaning that you lose most of your civil rights. So every right that you gained when you turned 18, plus the right to drive, which you got at 16, you lose when you have a guardian appointed, when you've been declared to lack capacity. So think about all the things that, the rights that you gained at 18, think about losing those, and that's why it's called a civil death. It is the most restrictive choice for surrogate decision making that we have. The things that we've talked about, advanced directive, power of attorney, medical directive, all those parts of an advanced directive, is a much less restrictive choice because, actually for a few reasons. Number one, because I make the choice about those things. I make the choice about all those parts of the advanced directive. In guardianship, that choice is taken away from me and it's made by the judge. It's also taken away from me because once a guardian is appointed, I can't make decisions about any of those things anymore. It's also the most restrictive choice because the court is involved, which means if I want to change it, get rid of it, I have to go back to the court and ask the court to make those changes or to terminate the guardianship. When someone is looking at the possibility of having a guardian appointed, that person has the right to be in the courtroom, and if they're in the courtroom, they're hearing everybody talk about every mistake they've made, every bad decision they've made, all of the disability that they have, and so there is a stigma involved in that, and there's a humiliation involved in that. There's also a stigma if you have to, disclose that you have a guardian. People are gonna be like, well, why do you have a guardian? Why can't you make your own decisions? So there's stigma involved with that. It does involve a court process, and usually it involves hiring an attorney. While you can do it without an attorney, I don't recommend it. Guardianship is one of those types of court proceedings that is very procedural. You have to follow certain procedural steps. And it's easy to get tripped up if you don't practice that area of law. So I do recommend having an attorney to do it. It's often unnecessary and it's usually permanent. Let's talk about that. It could be unnecessary because maybe one of the alternatives that we're talking about today could be put in place, and instead of guardianship. And it's usually permanent. The law does have a mechanism for either modifying the guardianship to give the person some of their rights back, or terminate the guardianship to give them all of their rights back. The issue with that is, number one, it's another court proceeding, so it's another having an attorney involved, it's another court proceeding. And the other thing is that you're going back to the same court who appointed the guardianship, appointed the guardian, and saying something has changed. Something has changed now since you appointed this person as my guardian, and now I no longer need the guardian. That can be, depending on the judge and the court, can be difficult to prove. If the person has a cognitive or intellectual disability that is considered permanent, it can be hard to prove to the court that so much has changed that they no longer need the guardian. And so that's why it's often permanent. So remember I said you lose a lot of civil rights. These are just some of them. You lose the right to make medical decisions for yourself. You lose the right to decide where you live, get married or divorced, the right to vote. That's a right we talk about a lot in an election, a major election year. You lose the right to enter contracts, make a will or advance directive. Think about how many times in a month you sign your name to a document. You sign your name to the document because you have the legal right to do so, because you have the presumed capacity to do so. Imagine you don't have the right to sign your name to any document. Those are the rights you lose when someone is declared incapacitated and has a guardian. And we're not done yet. There are so many that I have to do another slide. If you have a will, you can't change it once you have a guardian because you don't have the capacity to do so. You lose the right to drive. A letter is sent to DMV saying that if you have a driver's license, it is revoked. And if you don't have one, they have a note on file saying you're not allowed to get one. You can't possess a firearm, which is important to some families. Some families, like to hunt together and shoot guns together, so that could be an issue. Buy, sell, rent property, and if you have a conservator, then you also lose the right to make decisions about your money. Now, all that being said, I am not anti-guardianship, and the Disability Law Center of Virginia is not anti-guardianship. It is a tool in the toolbox. So if I think about a toolbox, let's say I need to I need to put a nail in a board, okay? Guardianship is the sledgehammer in the toolbox. So if I need to put a nail in a board, I could use a sledgehammer and I'd probably get the nail in the board, but I'd cause a lot of unintended damage to that board, right? So it would get the job done, but it would cause damage that I didn't want. Same thing with guardianship. Now, if I need a sledgehammer and the job I need to do requires a sledgehammer, then a screwdriver is not going to work, okay? So, and that's about the extent of my knowledge on tools, so I'm going to stop that metaphor. You know, guardianship may be necessary in some circumstances. Someone who's never had capacity, and given the medical information that we have now, probably will never gain capacity. For a person who's having a major, like say they just got that major diagnosis, and there's going to be a lot of decisions that need to be made, they may need a guardian. And remember, there is the option for limited guardianship. So maybe I can't make decisions about this complicated medical thing, but maybe I can make decisions about where I live, where I work, who I hang out with. So those rights can be protected. The judge can also protect rights such as voting rights. So I don't have the capacity to make decisions about this complicated medical thing, but the judge says, but I want Dana to maintain the right to vote. Those things can be protected in a guardianship, and that's considered a limited guardianship. So why alternatives? They are inexpensive. You don't have to involve lawyers, judges. It's easy to make it. It's easy to change it. It's easy to revoke it. I'm making my own decisions. I'm not, you know, a judge is not making a decision for me. A guardian's not making a decision for me. Anytime you can keep attorneys out of your life, that's a good thing. I don't have to worry about, you know, legalese language that I don't even understand. I can write it very simply. And the other thing about alternatives to know is that if I say I have a power of attorney, I am able to make all the decisions that I can make. And that power of attorney, that agent, only steps in to make decisions for me when I can't. The difference between that and a guardian is the guardian will make all the treatment decisions for me, even decisions that really I could make on my own, because the judge has declared that I'm incapacitated and can't make those decisions. So what does all of this have to do with people with disabilities? Well, I said at the beginning that everything that I've said is relevant for all of us. We all need to think about these things. You know, we're all vulnerable because we're all human. At any point in time, we could lose capacity, whether it be because we're getting older or an injury or an illness. So these are things that we need to think about. It's not fun to think about. It's not something that we want to talk about, but it is something that we need to put in place ahead of time. For someone with a disability, it becomes a very powerful tool. Think about that definition of capacity, the ability to take in information, make a decision, and then communicate that decision. Remember how I said to maybe talking to a doctor or a mental health professional or some professional that maybe doesn't know how to give them information in a language they understand, and maybe doesn't take the time to learn their communication system, and just very quickly decides this person lacks capacity. If a power of attorney or any other part of an advance directive is put in place ahead of time, then if the doctor makes that decision, it's okay. I've already put in place what's going to happen if that occurs. I've already decided who's going to speak for me when I can't. And hopefully that person that I've chosen, I trust to allow me to say, this is what I want, and then have that person actually give the consent or deny consent. So it gives people with disabilities a voice when that voice might be taken away from them by people or organizations or agencies or professionals who don't understand their disability or how they communicate. It puts that safety net in place for them. So they know that if that happens and they're declared incapacitated, by that doctor, by that second doctor, that's okay. They have that safety net. They have their power of attorney. They've already put things in writing that they want, that they know that they want and don't want. So that's why it's such a powerful tool for people with disabilities. So the other thing is when you're talking about, you know, maybe I truly can't make that decision about the brain tumor, the options of treatment. Maybe I really can't take that in. And so someone's going to have to step in and make decisions for me. I could depend on going down that list of family members if I trust that list. But remember, it says may. The doctor may get consent from one of those folks. So that's not a given. That's not an automatic. If I really want to protect myself, I'm going to put it in writing. I'm going to choose who's going to make decisions for me, and I'm going to put my choices in writing ahead of time. And I've just lost my train of thought. Choo, choo, train just derailed right off the station. So look at alternatives when you're thinking about, how am I going to protect this individual when they turn 18? How am I going to protect them in making decisions for themselves if they can't make them? Think about these alternatives. Think about naming someone to make a decision for them. Think about having them express their wishes in writing ahead of time. Train just came back into the station. So if I have that major medical issue that I cannot make the decision about, I don't have that brain tumor level of capacity, okay? Because of my disability, because of my cognitive abilities, I don't have that level of capacity. But I do have the level of capacity to say, I trust Liz to make those decisions for me. I can't make them, but I know that Liz is my friend, and I know I trust her, and so I want Liz to make that decision for me. That's much closer to the P's level. I have done powers of attorney documents with folks who are nonverbal, and the way I do that is I learn their communication system, and they are able to communicate to me who they want to talk to the doctor for them, who they want to make those decisions, sign those papers. I've had people use pictures. They pointed to pictures of who they want. They've used alternative communication systems, gestures. So it is possible to have the capacity to choose who I want to make decisions for me for those decisions that I don't have the capacity to make. We talked very briefly about other types of decisions, financial and educational. You can have powers of attorney for those things. A lot of the folks I work with don't really need a financial power of attorney. They don't have the assets. The only asset they have is Social Security benefit. And so that can be protected by having a representative payee appointed. They don't have the wages, or they don't own property or stocks or bonds or those sort of things to really need a financial power of attorney. They just need a representative payee to handle the monthly check that they get and paying their bills. If they do need a financial power of attorney, if it is a complicated thing where they own like property or stocks or bonds, something complicated, you may want to talk to an attorney about that rather than trying to do it on your own. There are certainly general types of financial powers of attorney online that you could try, but if it gets really complicated, then an attorney is the best way to go. We do not do financial powers of attorney because it's outside of our area of expertise. Educational power of attorney, if someone has an IEP, like I said, their rights transfer to them when they turn 18. Most schools still involve the parents, and the parents still have the right to have a say and all that. But with an educational power of attorney, you make sure that you have the right to receive notifications of meetings and evaluations. You have the right to be at the IEP meeting. You have the right to speak. By signing an educational power of attorney, that 18-year-old isn't giving up any of their rights. They still have the final say over their education decisions, but it allows the parents to keep their place at the table. Also, I found a lot of teenagers, believe it or not, have no desire to attend their IEP meetings. They would rather be in gym class or anywhere other than sitting in an IEP meeting. So educational power of attorney would allow their parents to attend that meeting and to speak for them at that meeting. So resources, like I said, the Disability Law Center has a supported decision-making web page, and this is that site. There's all kinds of information on that website. We also have, which isn't on this, and I should put it on here, we also have what's called a coming of age website, so that it has all kinds of information on it. When someone with a disability turns 18, all of those changes that happen with Social Security, with finances, with legal rights in the criminal world, all kinds of things that change when an individual turns 18. So if you go to dlcv.org and search coming of age, you'll find that webpage, which has all kinds of information for parents and individuals that are in that phase of life. VirginiaAdvancedDirectives.org also has lots of information. That's another good site. ConnectVirginia.org, that's where you can register your advanced directive. That's the state registry for advanced directives. So at this point, one final thing, capacity is presumed. That's so important to know, because so often for folks with intellectual and cognitive disabilities, it's just the opposite. Incapacity is presumed. But it's important to know that the law protects everyone by presuming capacity, regardless of ability, disability, IQ, whatever. Capacity is presumed in Virginia. So I am going to now, this is my contact information and the contact information of the agency. I'm going to leave that up, and Liz, turn it over to you for any questions.
Great. Does anyone have any questions? You can either drop them in the chat or unmute yourself.
And Liz, I have a question. Will this slideshow be available to folks after?
Yeah, so we, when we create the certificates, when we email your certificate to you directly, the PowerPoint presentation will be attached with it. The other option is to review it again on YouTube. I know information's changing all the time, but it'll still be there, and I'm sure it's still relevant for a little while. For hopefully a few months at the very least. We'll kind of monitor that. Oh, looks like we do have a question. If guardianship is required as a last resort, where do we start? What are basic steps?
So the steps for guardianship, you would consult an attorney who does guardianship, and you can, if you don't have one of those, and I will tell you the best way to find an attorney is talk to other parents, other families who've been through it. Word of mouth is the best way to find a lawyer that does this type of work and is good at it. If that is not an option, Virginia has a Virginia Lawyer Referral Service. So you could Google Virginia Lawyer Referral Service. And how that works is it's the Virginia State Bar, and you tell them where you live and what your issue is, and they will give you one or more attorney names and contact information, attorneys who are willing to give a 30-minute consultation for $35. And through that consultation, you can decide if that's an attorney who you want to work with, and if so, then you would work with them on what the fee would be and whatnot. But that gives you that first 30 minutes for $35. Okay, so you found your attorney. That attorney is going to petition the court for guardianship. We're going to file all the necessary paperwork for that. The court will then appoint a guardian ad litem, and the guardian ad litem, it's an unfortunate name because the person is not a guardian. They are actually the attorney for the court. They are the judge's attorney. They are there to do an investigation, look at the medical records, sorry, I have hiccups, terrible time to get the hiccups. They'll look at the medical information, talk to the individual, the person who wants to be the guardian, whoever else they need to talk to. Then they will file a report with the court and then present on the day of the hearing their recommendation. They'll do 2 recommendations. One, the first one is, do they think the person lacks capacity or not? You know, does the person need a guardian? That's the first thing, their opinion they'll give the court. And the second opinion is, if they do need a guardian, who's the best person to do that? Is it the person that petitioned for guardianship, or is it somebody else? The individual has the right to an attorney. It's important that the individual understands the guardian ad litem is not their attorney. So if Liz has hired an attorney to petition to become my guardian, Liz has an attorney, right? The guardian ad litem is appointed. That person will report to the court. The guardian ad litem is not my attorney. I have the right to my own attorney. If I don't agree with the choice of having a guardian appointed, I can have my own attorney. If I can't afford one will be appointed to me at the expense of the state. So it's kind of like in criminal law. You have the right to an attorney. If you can't afford one will be appointed to you. The same thing is true in guardianship law. Then the case goes to hearing. There are witnesses. I can cross-examine witnesses. I can present witnesses. I can even have a jury trial if I want. That's my right under the law. We have the hearing. Either that day or shortly thereafter, the judge will make a decision about whether I need a guardian or not. If I don't need a guardian, case closed, it's over, I go home and celebrate. If I do need a guardian, then the court will decide who is the best person to do that. Is it the person that petitioned? Or is that person not the right person for the job? So Liz could petition to be my guardian, and the judge decides that because of a conflict of interest or because of some issues Liz has in her own life or whatever, she's not the right person for the job, and he can appoint somebody else. So that's the process of how a guardian works, guardianship process works. So Liz would be paying for her own attorney. Liz would also be paying for the guardian ad litem. Those 2 things are paid for by the petitioner. However, if I, as the person she's trying to become guardian over, if I have assets, Liz can ask the court that I pay not for her attorney and for the guardian ad litem. And the court can order me to pay for those things, even if he doesn't appoint a guardian. So if he thinks Liz did it in good faith and wasn't doing it just to be spiteful, okay? So I could get a guardian, and not only that, but I get the joy of paying for it. That's how our law works.
All right, another question. If my 18-year-old is in college, when they sign the FERPA form, we get access to academic info, right?
I'm not an expert on FERPA, but that is my understanding. I would definitely look to see how the release form is written to see what information you get access to under that form. If the student signs it, I'm assuming they get a copy of it. You'd want to look at a copy of that just to see how it's written and to see if there are any exemptions, things that you don't get access to. An individual can always write a power of attorney document to include information. You know, like say you get a FERPA form, but it doesn't include information if they go to student health. Let's just, I mean, I have no idea, but just use that as an example. A person can have a power of attorney and say, I want my agent to have access to my student health records. So you can always get, you know, access in other ways other than just signing a release form.
What happens to a person when the guardian passes away?
This happens way too often, and it's a very complicated legal problem. Let me first tell you how you can solve it before it happens. You can prevent it. Virginia law allows the court to appoint a standby guardian. So when I talk to families and they've decided, they've looked at alternatives, they're not going to work, they do need guardianship, I highly recommend I couldn't more highly recommend that you also appoint a standby guardian. So it's kind of like that alternate in a power of attorney, so that if it says if the guardian is no longer available, whether that means that the guardian is away on a cruise, or the guardian has died, or the guardian develops dementia and is no longer available cognitively, then someone else is appointed as that standby guardian. If you're going to go to court and you're going to pay the fees and you're going to go through all that hassle, get a standby guardian appointed at the same time that you appoint the guardian. What happens if you don't have a standby guardian and the guardian dies? It leaves the person in a very vulnerable state, because at that point, they have been declared incapacitated, so they can't make their own decisions. But now the guardian has died and there is nobody who's legally capable of making their decisions. So if a decision needs to be made, the only options are, number one, someone can go to court and get appointed their guardian. It's a much simpler process because the person's already been declared incapacitated. At that point, you're just looking for who's going to be appointed that next guardian. So that could happen. If that doesn't happen, then the court is really the only available person to give consent if consent needs to be made. And if you know, say it's a elderly parent who has died and they were the guardian and there are no siblings available or willing to take on the task, and the individual has not had children, and I mean, and there's nobody, Virginia law, I mean, we do have a public guardianship program in Virginia, but it is way overtaxed. There is a waiting list for those services, and I don't think that it is yet available in all parts of the state. So while that's an option, it's not an option you can depend on when the time comes, because there is a waiting list. So please, if you're going to go the route of guardianship, have that standby guardian appointed at the same time.
What price is fair for guardianship?
It varies significantly across the state. So I really can't, I mean, we're talking thousands of dollars, not hundreds. You may be able to find a lawyer who's willing to do it at a reduced rate. For guardianship proceedings, you might be able to pay a flat rate rather than an hourly rate. Most of the time when you hire an attorney, it's based on how much that person charges per hour. And that can range anywhere from $250 to over $500 an hour. But for things like guardianship, a lot of times they'll charge a flat rate. So then you're not entering into it having no idea how much it's going to cost you. But remember, you will be paying the petitioner, your attorney, and you will be paying the guardian ad litem fee as well. So it is not cheap. Remember, I said one of the reasons we look at it as a last resort, one of the reasons is expensive. Anytime you involve lawyers in your life, it's expensive. Again, the way to find those attorneys, word of mouth. The problem with that is if I have an attorney who did it for me for a reduced rate, and then I tell, you know, all my friends in my support group, hey, I have this attorney who'll do this for, you know, and then that attorney gets overwhelmed and then he's like, never mind. I can't continue to do this. So sometimes word of mouth works for that, sometimes it doesn't.
Right. Is there any information you're aware of in regard to maintaining health insurance benefits, specifically TRICARE, past the age of 26 for children with disabilities, and whether guardianship is necessary to maintain those benefits?
I don't know that. And my knee-jerk reaction to that is guardianship would not affect that. But I am not an expert in insurance type issues, so I don't want to provide an answer. I can't provide an answer other than I don't know. I'm sorry.
All right, we have a couple more minutes. Does anyone else have any questions? Any more questions?
While we're waiting, I will say that we have a person available to take calls Monday, Wednesday, and Friday from 8:30 to 4:30. If you have specific questions about, you know, what we've talked about today, you know, take a look at the resources on our webpage. I'm going to go back to the resource page. If you look at that and you still have questions, you can call Monday, Wednesday, or Friday to our toll-free number, which of course I just moved away from. Call our toll-free number or our Richmond office, or you can also email info@dlcv.org. And also on our webpage, there's a button for Get Help. So there are many ways to reach DLCV if you have specific questions about your family's case, or you know, if you're supporting someone in the community and you have questions, feel free to call and speak to that intake specialist. She takes information, basic information, and then someone will get back to you who is sort of an expert in that area to talk to you through that issue. So, any other questions?
Would you say that calling for any insurance related questions, they could call that number too? Insurance
related, they can certainly call. I don't know, we have someone there whose expertise is Social Security. I'm not sure if she knows anything about insurance. But even if we don't have the information, we try really hard to figure out who can give you that information and refer you to wherever you can find that answer. We try really hard to do that. And don't forget before you leave to say goodbye, right?
Yes, thank you, Dana.
Another
Perfect.
question?
And CA also, we try and provide and connect resources for anyone across the state as well. So if you try Disability Law Center, and maybe they couldn't find you someone, we also have access to No Wrong Doors database. So we might be able to connect you as well. So feel free to call us both. And someone, typically we can get you a list of a few resources within a couple of days. Any other questions?
My email is at the bottom. Feel free to email me if you'd like. If it looks like an issue that we may, provide more than just an answer to a question, I might refer you back to that intake specialist to go through the whole process. But if you just have a quick question or something you want to email me, feel free. If you want to send me cute little kitty cat memes, feel free to email me those as well. I need a little positivity in my life, don't we all? Thank you all very much.